Hi, this is Kirk Davis. This is Ralph Flick, a new member of CAMPS who is general counsel for businesses of all sizes. I've gotten the chance to know Ralph, and you were introduced through your wife, Wendy Flick, who is a board member of CAMPS. And
Correct.
I was happy to meet you because Wendy, of course, has said so many wonderful things about you, but your background is so unique. And of course, you provide legal services for businesses, but there's so much more to you. And first of all, you're a teacher,
That's
and
right.
we were just talking about your community service. So could you bring the audience up to speed on kind of your practice, but how that works with your teaching?
So I teach business law at Pacific Lutheran University. I teach in the undergraduate and in the MBA program. I teach other things too, but my primary discipline is business law. And this is not at a law school. It's in a business program. So I teach undergraduate and graduate business students. And as we were chatting, one of the things that I often am constantly surprised about, I shouldn't really be surprised after all these years now, but the overlap. So it's very often whatever topic is going on in class, whether that's business entities or secured transactions or contracts or whatever the thing is we're talking about, it's uncanny how often that same topic comes up with a client that same week. It's almost odd how often that happens. But I think it happens because the overlap is in the topics that I teach with the topics that I also advise on is very high. It just probably feels more odd than it actually is. I do teach, again, both undergrads and MBA students. I have my MBA also. So I have a business background and I focus primarily exclusively on business transactions. I'm not a litigator. I've never been involved in a case other than having a supervising outside counsel who litigate for my clients. So I'm limited strictly to advising businesses, again, as you said, of all sizes, to make risk and business decisions. Fundamentally, that's what I do. And that's also what I teach.
I think that this is very exciting for CAMPS members to have access to somebody like you that can help them with these business transactions. And you've been teaching at PLU, is it 9 years now?
I'm starting my ninth year.
Your ninth year, and you're a tenured professor there, which I think is
Mm-hmm.
fabulous. And you mentioned that you moved from California about 15 years ago to get,
That's right.
and you've been actively involved in the community. I think it'd be, I think that the fact that you're so involved in the community really says a lot about you. And so run down some of the things that you've done in terms of your community involvement. I think it's really interesting.
So when we moved here, we didn't know anybody and we had young kids. That was why we moved here. This is where we chose to raise them. And we made a conscious effort to be involved in the community that we raised our kids in. We were largely involved in those early years with things that the kids were involved in. I was the co-president of our PTA. I was the leader of an adventure guides group. I coached baseball and soccer and all the other things the kids were involved in as they grew up. I was also, over those years, I joined one of the Rotary clubs here in Gig Harbor in 2009, I think it was, and served been an active member. I was a president of that club for a year as well. We've tried to be very active members of our community, but our focus is largely on raising our kids. And it was actually my wife that came up with this idea. We look for involvement activities that our kids could see. So we did things like volunteer in the classrooms. I don't know if you're familiar with junior achievement. Have you ever heard of junior achievement?
For sure.
Yeah. So I was a junior achievement volunteer all the years of all my kids. I taught the curriculum all the way kindergarten through fifth grade, because in fifth grade, they go to BizTown in Kent. So I was involved with that. I ran the Watchdogs program, which is dogs and dads of great students. It's a program that brings dads into the classroom. And I was the one that ran that program for our school. So we always looked for things that had meaning to, and that our kids could see us doing. We tried to stay away from the things that involved committee meetings that took us away from our kids and looked instead for opportunities to improve the environment that our kids were growing up in.
Wonderful.
Yeah, our son lives in Portland now. He's on his own, almost on his own. And our daughter is just graduated from high school and is going to be a freshman at PLU in September. So now we're entering the empty nest phase of our lives. And so we're not sure what that's going to bring as far as our community involvement, but we'll still be involved.
It's actually wonderful to think about your background teaching and doing law, because when we first talked, you shared with me a lot of stories and you have a lot of experience. And I want to help the camps members really understand some of the different aspects of your law practice. But you had experience in house working for
Mhm.
companies, but also this private practice. And of course, I think private practice suits you very well.
I'll give you the quick version of this, but I had the opposite legal career of most lawyers. So most lawyers, you come out of law school, you go to work in a firm and then either go the partner track or go in-house at some point. When I got out of law school, my first law job was an in-house position. And so I started as an in-house lawyer. And I worked for a series of publicly traded companies, worked my way up the corporate ladder inside the corporate legal department at a number of these publicly traded companies, and did a variety of general counsel style work. And one of the things about being a general counsel is you're a general counsel. It means you handle a wide range of things that advise your client, which when you're in-house is your employer. You only have one client in that scenario. And you're part of the management team. You're not just advising a client, say, here's the law, you make a decision. Instead, it's more, here's the law, let's make a decision together. You're part of the decision-making team. Then I went to a large law firm for a few years and then started my own firm. So I've had literally the opposite trajectory, but I've advised clients in-house. I've advised clients as a lawyer in a large law firm, and I've advised clients as a solo practitioner. So I've done really all of those. And it's always been transactional, business transactions, corporate contracts. That's the kind of thing that I deal with. And then often advising clients when they need another expert and helping them find that other expertise. That's something a general counsel does. Many general counsels at big companies, really all they do is supervise other lawyers. So you get to know what there's a skill set in finding the right resource. So I often help clients with that as well, help them manage that. I really prefer working with clients on a long-term basis. That's really where my skill set seems to be the best. I can handle projects, I can do M&A deals and so on, but I really, where I bring the most value is when I really am a part-time general counsel for a client and work with them, get to know their business, get to know their risk tolerance, help them evaluate these decisions, review their contracts. When you know the business, it's so much better because you know what risks to look out for and so on. So that's really the niche that I've evolved into as a solo practitioner, is to be this part-time general counsel. And that seems to work really well.
One thing I was going to mention, that working as general counsel versus just a project by project, and getting to know somebody's company, you can actually see problems before they occur.
Totally.
You can strengthen that whole legal foundation of their company, because as companies grow, they become a lot more susceptible to contract risk. They become a lot more susceptible to maybe lawsuits, where if you can strengthen that legal foundation for a company, have that time, really take a look at what they're doing and how they're doing it, and making certain that they've crossed all their T's and dotted all their I's. And especially when it comes to compliance. And
Yeah,
it's just, there's so many manufacturers, when it comes to regulations and compliance, manufacturers have so many needs like this.
for sure. But I think what's important is understanding the business. It takes a while to get to know a business, but understanding that particular business and where its risk points are. You could look at a contract, and this used to be my complaint back in my in-house days. A business person would email me a contract and say, review this. And that's it. And there's not a lot I can do with that, because I don't know, what is it that you've negotiated? What are your concerns? Who is this counterparty? Are they reliable or are they not? Do we have any risk concerns with providing our obligations under this contract? Let's call that context. And it's very difficult for a lawyer like me to do much more than just take a guess when I read something like that, unless, if I know the business, if I know where the problems are, where I know where the risk concerns are, I know where issues have occurred in the past, then I can take that context and look at that contract and make comments to it or draft it in a way that that is in the best interest of that particular client. And that's going to be different from client to client and business to business.
What I really like about the fact that you're a full-time faculty at PLU doing this is these topics that you're teaching are just
Mhm.
really relevant to what's happening in business today. And so it really, and I'm sure what I'm about to say isn't 100% accurate, but it would be difficult to surprise you as
That's an interesting statement because I've been doing this 30 years now. So you'd think that would be the case, but I'd say most of the time that's true. But a business broker who I do a lot of deals with, we work together on a lot of transactions. We have this joke that every deal is different. So no matter how many deals you work on, every deal is slightly different. And we don't know what the issue is that's going to pop up that we have to deal with. We just know something will. And it's always something different. So on the one hand, you're right. You do this enough times, you read enough NDAs over the years. I can read an NDA and comment on it very quickly because I've read probably thousands of those over the years.
Yeah.
But when I'm selling the business assets of a particular type of business to another type of business, that could be very different.
Yeah.
We've had this happen, deal failure. So we have a client who's selling a company, go all the way down the road, something happens, they walk away. And so then we go find another buyer and we do that. Sell the same company to a different buyer, completely different transaction because the buyer's issues are different. There's just so many things that vary from one transaction to another. So there are commonalities, but then there's always uniqueness.
And I think that in this litigious society that we have, it's just so smart to pre-plan your legal activities.
Essentially, that's what somebody like me is supposed to do. My job is to evaluate this transaction and try to spot the risk points and then make the agreement as favorable to the client as I can get. That's the whole objective. But at the same time, a point that is like the underlying theme of my business law class for the whole semester and something I talk to both clients and students about, you don't make money unless you take risk. If you don't want any risk, then put your money in, buy T-bills.
Yeah.
Right. But the fact is that if you are involved in anything other than that, you are by definition taking on some risk. Yeah. So it's not that risk in and of itself is a bad thing. What I try to get across to both the students and clients is the point is to make a thoughtful and knowledgeable risk decision. It's okay to make a bet as long as you understand what the consequences of either side of the bet are. What's bad or what gets people into trouble is when they don't understand the true consequences of the wager that they're making. And then they're not probably charging enough or maybe making decisions that later they might regret. So it's really this is where the two cross over a lot because the teaching and practicing law, because really it's my job to educate a client in this way is to say to them, these are the bad things that could happen. Here's what we can do to try to adjust for that. Here's what we can't adjust for and the risk you're going to have to take if you go forward. And that's essentially the job, really.
I think that's wonderful. And this kind of falls into the same thinking, but as a business grows, maybe gets more complex, there sometimes becomes a need for multiple business entities within the company, or if they're involved in mergers or acquisitions, there can be this need for business formation opportunity.
Mm-hmm.
But what do you find in terms of the logic of maybe separating out assets or parts of the company entities? Any thoughts on that?
There's two big categories of decision points on that. It's often driven by one or both of tax or liability segregation. Tax tends to be the more common, in my view, motivator for how and why to structure deals. Because in my view, in my experience, clients will sometimes come in and overthink this. I want to open this different division. So I want to have a different brand. I want to have a different checking out. So I need to create a corporation for that. We don't need to do that. We need to go through the analysis and decide if that on par gives you the best outcome based on what you're trying to achieve. Sometimes you can just get a DBA and open another bank account and operate a division without a separate entity. there's very frequently tax consequences to this, particularly when you have money services being running between entities. Both the state and the IRS hate that. And there's certain things you have to do to do that correctly, to get the benefit of it and not get in trouble with the taxing authorities. So there's a very long sort of decision tree that you would go through when you're deciding on entity formation and deal structures. In the M&A context, I'm just dealing with this right now. I'm just doing a deal right now. Most M&A transactions that are on the smaller side, what we would call Main Street deals or small deals, are done as asset purchases. Almost 95% of the time, I would say they're asset purchases. So the seller isn't selling their company. They're selling the assets the company owns. The buyer is buying those assets. As you get into the larger transactions, it flips. They're almost always purchases of the equity. And a stock transaction is much easier from a technical perspective because you just sell the shares and employees stay in the same place. The contracts largely don't need to be assigned, and some still do, but most don't. So it's very easy to just say, okay, here's this corporation. We'll just sell you all the shares. Now it's yours. But in the smaller deals, that's almost never how it goes. And so you have to go through the exercise of identifying the assets, transferring the assets, firing the employees, have the buyer buy them, assigning the contracts. It's much, much more complicated.
Boy, that's where I would imagine your value really comes out in those types of transactions.
That's basically what I do in those transactions. I think the way I often describe myself is I'm the legal quarterback. So I don't know all the tax stuff. So we get tax experts to advise the client on what's optimal tax wise. I may not have a particular expertise in very niche areas of environmental law and employment law and so on. So we go and we get experts to come in on those parts. And then my job is generally to manage the purchase agreement and coordinate all of the assembly of documents and everything to get that deal to closing. That's typically what I do. And that's where I that's the value that I bring. Hopefully bring value.
And I'm thinking about this from a CEO perspective or a business owner perspective, but oftentimes the term legal quarterback was going through my mind all throughout our conversation. I'm like, wow, this is just like a legal quarterback. And the fact that the CEO probably has so many other things to worry about, the fact that they can hand it over to you and you can manage all those details, the paperwork, the legalities, the taxes, the niche regulations and things of this nature. What a relief. That's a big relief.
Yeah. In the deal that I'm working on now, this is exactly the case, is that he's trying to continue to run his business. He's a very busy guy and that he needs to run that business. The deal could fail. So he needs to run his business as if the deal wasn't going to happen. And on the side, we need tax returns for years and financial statements. And we need to create all these schedules that are attached to the purchase agreement. And he doesn't have the time for that. His staff is busy. So he sends me I get the diligence folder. So I go put all that stuff together and then bring the issues to him that he needs to make decisions on. And that's expensive, but if you consider the value of his time, it's much more efficient for him to hand that off to me. And I know how to figure out most of it on my own. And then I go back to him with the stuff that, we have occasional meetings and go through punch lists of things that I need from him, but I manage the deal overall.
And that to me is very valuable. The fact that I think a CEO who's trying to be both a legal quarterback and run the company is impossible. Think about everything that has to be done. So I think you bring a lot of value. One of the areas I see a vulnerability for a lot of companies is vendor and customer contracts. Because I think that they think at the handshake level, they think they're going to be happy. I'm going to be happy. There's not going to be a problem here. However, when things go sideways, if you're not prepared, what's been your experience with vendor and customer contracts?
I think we only have, what did you say, 40 minutes, right? Well, that sort of the big things are, I would say one of the biggest problems I see is just that this is on both sides of a contract, the parties just really don't understand what it is they've signed. I've seen it over and over the years when whether it's a customer or a vendor, when you're at the point where you are ready to do business together, it's everyone's happy. Everyone wants to be, only want to talk about the good stuff, which is all the wonderful things that are going to come from this contract. And sometimes business people have trouble at that point in time having conversations about what happens if the expectations that we have about this contract aren't met, and what are the consequences and remedies of that. And so I'll get a version of, they send me the agreement and I say, what about this problem? And then I'll get an answer, something like, we don't expect that to happen. These aren't those kinds of people. That's the response. And I respect that. I understand that's why they're doing business with them in the first place. But all of these, you wouldn't sign up if you didn't think that the expectations were going to be met, but the expectations aren't always met. So you have to have that difficult conversation up front. And there's a way to do it that is respectful to the counterparty. So I'm not saying to the counterparty, oh, we think you're going to breach, so we need all of these protections against it. We say to the counterparty, we want to do business with you. We just need to protect ourselves, and so do you. And
we want some guardrails. We want some guardrails.
For sure. Like I always say to clients, the person you're dealing with now may not be the person you're dealing with later when something goes wrong. And so all of the goodwill that you have with the salesperson isn't going to be there later when there's a breach. You're going to be dealing with a different person. The company might sell itself. You might be dealing with an entirely different counterparty. That's what I always say to clients who come in to start a new business. I trust this person. That's why I'm going into business with them. The person was fill in the blank, best man at my wedding, met him at church, met him at school, whatever it is, whatever the affinity is. But then what I always say to them is, what if they die? Then guess who your new business partner is? It's their spouse. And you may not have that same relationship with the spouse. So you have to, even though this person is a trusted counterparty, you still have to be careful in those contracts. And that same dynamic occurs when somebody either wants to buy something from somebody else or sell something to somebody else. You have that same kind of dynamic going on.
That is the classic buy-sell agreement between owners, right? Between partners.
Correct.
I've helped dissolve, in my business experience, 4 lifelong friendships that when they went into business together, one person did all the work, the other person did nothing. And they were best friends forever. And this was never going to happen. And boy, the ugliness of that separations I wouldn't wish on anybody.
I've seen it so many times, and I have to be careful that I'm not perceived by the client as being too overly negative sometimes. But I've seen so many of these examples. Yeah. Of the 2 people sitting across the table from me saying, we're friends, help us form this LLC or whatever. And then a year later, one of them calls me and says, the other one's a complete fraud. I need to sue them. All this kind of happens all of the time. Yeah. And that same dynamic exists when you're working with a major customer or a major vendor. You go through the exercise of deciding that you're going to get into business together, and you only do that if you feel good about it. And you don't at that time want to talk about the consequences. In class, I bring a contract from an old finance deal that I worked on years and years ago, and I show them. And physically, it's a whole book of contracts. But we pull out that main agreement. It's 80 pages long, and the first 3 pages describe the business transaction. All the rest of it is representations, warranties, indemnifications, remedies, all the stuff. Most of the ink in a contract deals with the things the if-then problems that might happen in the future. The underlying business deal, I'll sell you this for this price. You can describe that in a paragraph. And then all the rest of it is all the other things that you have to deal with.
Those contracts, when I find that they're that long, it's usually, unfortunately, because of experience. They've seen some things, they've been through some things. And so it's become very,
every paragraph has a real story to it, a problem that happened that resulted in people starting to put that in the contract. So it's like the years and years of experience that's incorporated in there. And this is also, and let me know if I'm going too long, but this is also unique to the US. So the rest of the world doesn't do business like this. And most of the rest of the world doesn't. And when you're doing international transactions, which a lot of manufacturers are doing, if your counterparty is in Asia or in Europe, they're not at all used to a 80-page contract with pages and pages of reps and warranties. They get very annoyed when you send those contracts to them, because in their culture and in their legal system, which in most places of the world, the legal system's different, civil versus common law. Yeah. You don't have to have these super long, detailed contracts that deal with all of these potential litigation risks like we have in the US. So that's another common element that you have to deal with, is learning to protect the interests of a US seller or importer when you're transacting with someone from the EU or somewhere in Asia or even South America. It's different in those places.
And I'm just thinking of the value you would bring to somebody who maybe hasn't seen some of these things. And you've had this 30 years of seeing things and saying, we better look out for this or watch for that. And I just think that's so valuable. One of the areas that I think you help businesses with is corporate compliance, which is a monster in manufacturing.
Yeah.
And I just think that's an area where you can add so much value. What do you talk about in terms of compliance?
So in the case of compliance, I don't pretend to know the regulation that impacts every potential manufacturer or client across industries. This is where learning the business is helpful. There are some industries where I have more experience than others. But really what I tend to do, similar to being the quarterback on an M&A transaction, I know how to set up and run a compliance program. So I may not know we may have to go to the expert to tell us, here's what the regulations are. What I work with clients on is developing a policy and then a system for implementing that policy. One of the biggest problems that I see, and this is across a wide variety of risk areas, including employment and so on, is companies understand they need a policy. So they write one or they download one from the internet or whatever, and then they stick it in a drawer and don't necessarily follow it themselves. And if you want to create a risk trap for yourself, that's the easiest way to do it. Because if you have a risk event, the plaintiff's lawyer, the first thing they're gonna request in discovery is a copy of your policy. And if you turn over a copy of this policy and it says, we're going to do X, Y, and Z, and then you systematically didn't do those things, you've just given them the case. It's almost better, and not that I'm just for the sake of argument, it's almost better to not have a written policy than to have one that you don't follow. So what I do with clients, I work with them to figure out what their compliance issues are. If I don't know them, we go find them and then draft reasonable, workable, followable policies, and then a system for tracking your compliance so that later that provides you with a degree of protection against that kind of risk. It's not bulletproof, but you definitely want in a situation like that to be able to say, here's our policy and here's the records that indicate that we have implemented and complied with it. And that provides you with a wide range of protections against risk. Insurance companies often require it as part of your insurance coverage too. So insurance is another big issue. I deal with a lot of clients with making sure they have proper insurance and making sure that they are doing the things that the insurance company is expecting them to do. Your insurance companies typically, they don't make money by paying claims. They make money by collecting premiums and not paying claims. So they're going to look for every reason not to pay a claim that they can. And so your compliance program, in addition to protecting you against risk, also is a way of ensuring that you're or helping to improve the odds of a successful insurance claim.
Incredible. Actually, I'm hoping that everybody who's listening to this says, I really need Ralph to help me with all of the different areas. It's very complex, but manufacturing is complex.
Okay.
And unfortunately, because of regulations and compliance, and one of the last things I wanted to talk to you about is the way that you can help them with HR issues, HR support, because that unfortunately turns legal as well.
It does. I've done HR my whole career, basically. When you're a general counsel, you almost always are involved to some degree in HR. I used to actually teach the HR class at PLU. I taught the intro HR course. But it's in the 30 years I've been doing this, it's been a real evolution. In 1996, when I first started my first corporate job, that was a few years after law school that I got my first corporate job. Graduated law school in 94. But HR was considered, it was the payroll office. And it was seen as just an administrative function. In the 30 years since, it has really changed to become part of the top level strategy. So most big companies will have a chief people officer or a chief human resources officer, someone at the C-suite level.
Yeah.
And that was not the case in 1996. So HR has gone really from being this administrative function to this strategic function. But that doesn't change the risk profile of it. So I don't do the HR strategy stuff. That's for HR strategists. Yeah. Where what I do is things like handbooks. And the handbook is the classic example of what I just described. I can't tell you the number of handbooks I've seen when I asked a client, send me your handbook, and they haven't even changed the name. They downloaded it from somewhere else and didn't even do a find and replace and change the company name. And I was like, we need to fix this. But what that tells me is that they knew they needed a handbook. So they got one and said, this is our handbook, check the box, done. And that is a very dangerous thing to do because who knows what's in that handbook. And if it says things, if it states policies that you're not complying with, there's a big trap there. Independent contractors, another big risk area that has evolved dramatically, especially in the last few years. Much, much, much more difficult to classify workers as independent contractors than it used to be. And so that's an area I spend a lot of time drafting independent contractor agreements, hiring and firing, that goes to the compliance aspect of it, having a good hiring process and a thoughtful and risk managed termination process. That there's what I like to tell new entrepreneurs is that the single biggest expanse of your risk as you're growing your business is employee number one. And you go from it just being your friends and your founders working together to that first hire. You just dramatically stepped up your risk and compliance obligations. And that's difficult for some smaller companies to understand and to put resources towards. But it is the single, I would say in manufacturing, probably your regulatory and environmental compliance risk is probably your number one risk, but employment risk is at least number two, if not tied for number one. And for every other kind of business, service businesses, employment risk is by far the biggest risk that they face.
I think that the CAMPS members who look at this will say, Ralph would be somebody who would be really great to work with. Your communication skills, your teaching skills, 30 years of legal practice. And we can tell as we walk through all of these different areas that you're somebody who's been there, done that, seen that, and could really add a lot of value to it. To really, you kept talking about risk traps. And so I hope that's going through people's minds, because essentially, if we don't have this general counsel and we don't have this overview of the business and the risks, there's just so many areas where manufacturers can get into trouble.
For sure. And one thing I would say also, I never mind taking a call. It doesn't always turn into a lawyer-client relationship, and that's fine. If somebody has a question and they just need to know, they don't even maybe know what help they need. I always have, as long as I've been practicing, I've always taken the approach that there's just a certain amount of calls you take that are just sort of goodwill. So I don't mind taking a call from someone who has a question and needs a quick answer. Maybe I have to be careful of where the lawyer-client relationship begins, but I'm always willing to take a call and help somebody if I can't help them find the help that they need.
That's a wonderful attitude, and one where sometimes you worry about calling attorneys, and now we don't worry about calling you. That opens up the door very nicely. I have to tell you, Ralph, this has just really been incredible, because I don't think I've met anybody with your depth and breadth of experience. But I know from personal experience how teaching on these topics like you do informs your practice, and how your practice informs your teaching.
Mhm.
and how, the students, I think, are very fortunate to have a real practitioner as a teacher. So I'm really encouraging camps members to get to know Ralph. You'll see him at events and you'll get to know him. And he's somebody who can add a ton of value to your organization. So thank you for your time today.
I really appreciate all of that. And I look forward to getting involved in the organization. So I really appreciate the opportunity.